Hello, my name is Loveleen Bhular and I'll be making a presentation on the topic Laws Relating to Air Pollution in India. Before we start, a brief background about air pollution. Commonly, air pollution is defined as the presence of a pollutant in the air or in the atmosphere. There are broadly two main types of air pollution, indoor air pollution and outdoor air pollution. Now, the causes of indoor air pollution include smoking, inefficient burning of inferior fuels and poor ventilation, whereas the causes of outdoor air pollution include vehicles, industries, power plants, mining activities, construction activities, firecrackers, cigarette smoking and crop burning, etc. Air pollution is an issue which requires urgent regulation, and the need for regulation is borne by the fact that a recent report of the Central Pollution Control Board from the year 2010 has said that the particulate matter in the air of 180 Indian cities was 6 times higher than the standards laid down by the World Health Organization. An even more recent report from this year, which is released by the Yale Environmental Performance Index, has ranked India as number 174 out of 178 countries in terms of air pollution. Clearly, it's a very serious issue requiring urgent attention. The objective of this particular module is to introduce you to the legal framework concerning air pollution in India. We'll be looking at the features of the Constitution of India, the Air Prevention and Control of Pollution Act 1981, a specific law on air pollution, the Environment Protection Act of 1986, which is the umbrella environmental legislation in India, as well as the Environment Protection Rules of 1986 framed under the Environment Protection Act. And also we'll be looking at some of the important judicial decisions, primarily from the Supreme Court of India, dealing with specific aspects of air pollution. Insofar as the Constitution of India is concerned, there is no specific provision on environmental pollution generally or air pollution specifically. However, the Supreme Court of India has broadly interpreted Article 21 of the Constitution, which guarantees the fundamental right to life, to include the right to enjoyment of pollution-free air. This was done in the case of Subhash Kumar versus State of Bihar, a decision from the year 1990. The specific legislation on air pollution in India is the Air Prevention and Control of Pollution Act 1981. Now, this law is basically a consequence of domestic implementation of a decision which was taken in 1972 at the historic Stockholm Conference, also known as the United Nations Conference on the Human Environment. And the decision taken at this conference was to take appropriate measures to preserve air quality and to control air pollution. Now, the Ministry of Environment and Forests at the central government level exercised its power vested in it by Article 253 of the Constitution in order to make this law implementing a decision which was taken at an international conference, namely the Stockholm Conference. The primary objective of the Air Act is to prevent, control and abate air pollution. The term air pollution has been defined in the Air Act as the presence in the atmosphere of any air pollutant, and the term air pollutant has been defined in the Act as any solid, liquid or gaseous substance, including noise, present in the atmosphere in such concentration as may or tend to be injurious to human beings or other living creatures or plants or property or environment. The responsible agencies under the Air Act are the same as under the Water Prevention and Control of Pollution Act 1974, namely the Central Pollution Control Board at the central level and State Pollution Control Boards at the state level. At the central level, the Central Pollution Control Board or the CPCB is responsible for improving air quality and for preventing, controlling or abating air pollution. For this purpose, the CPCB is responsible for laying down air quality standards, and these have been laid down in the form of the National Ambient Air Quality Standards 2009, which deal with areas such as industries, residential areas, rural and other areas, as well as ecologically sensitive areas. At the state level, the State Pollution Control Board is responsible for discharging a number of functions which affect air pollution. These include laying down, in consultation with the Central Pollution Control Board and having regard to the air quality standards laid down by the CPCB, standards for emission of air pollutants from industrial plants and automobiles into the atmosphere, or discharge of any air pollutant into the atmosphere from any other source which is not a ship or an aircraft, because ships and aircrafts are dealt with under separate laws. The other function that the SPCB is required to perform under the Air Act is to advise state government on the suitability of any premises or location for carrying on any industry which is likely to cause air pollution. Under the Air Act, the state government has also been given the power to notify certain parts of the state as air pollution control area or areas. This power has to be exercised by the state government in consultation with the State Pollution Control Board. Now, once an area has been designated as an air pollution control area, certain activities are prohibited in this area. For example, the use of non-approved fuel or non-approved appliance and or burning of any material which is not a fuel. Both of these terms, approved fuel as well as approved appliance, have been defined under the Air Act. Now, the reason for this prohibition is if such a non-approved fuel or non-approved appliance may cause or is likely to cause air pollution. The decision to prohibit such fuels or appliances is to be taken by the state government after consulting with the State Pollution Control Board. The other important legislation from the point of view of air pollution is the Environment Protection Act of 1986, where the definition of the term environment includes air. The definition of environmental pollution means the presence in the environment of any environmental pollutant, and the term environmental pollutant means any solid, liquid or gaseous substance present in such concentration as may be or tend to be injurious to the environment. Under the Environment Protection Act 1986, the Ministry of Environment and Forests has been given a number of powers, one of which is to take measures to protect and improve the environment. Under the exercise of this power, the MOEF can lay down emission or discharge standards for air pollutants. The MOEF also has the power to make rules to regulate air pollution. For example, laying down air quality standards for various areas and purposes, and laying down maximum allowable limits of concentration of air pollutants for different areas. Again, as in the case of the relationship between the Environment Protection Act and the Water Act, in this case as well, the standards under the Environment Protection Act and rules will be placed in higher capacity over the standards under the Air Act. The other relevant source of legal provisions are the provisions relating to public nuisance. Such provisions are found in tort law under Section 268 of the Indian Penal Code, Section 133 of the Code of Criminal Procedure, as well as Section 91 of the Civil Procedure Code. However, the length and expense of litigation which is involved in proceeding with such public nuisance claim and the difficulty of establishing liability has usually prevented individuals and groups from pursuing this form of remedy. Now, moving on to some specific forms of air pollution. One of the more common forms of air pollution is industrial pollution. Now, the Air Act states that an industrial plant in an air pollution control area requires previous consent to establish from the State Pollution Control Board. Also, such an industrial plant, once it starts operating, is not permitted to discharge any air pollutant in excess of the standards laid down by the State Pollution Control Board under the Air Act. Otherwise, such a plant would be subject to penalty which takes the form of imprisonment as well as fine. Also, under the Air Act, a person may be restrained from emitting an air pollutant. Now, as in the case of the Water Act, the State Pollution Control Board does not have the power to impose penalty or restrain a potential air polluter unilaterally. In other words, the State Pollution Control Board has to file a complaint or an application before a court of law, and the court of law will take cognizance of such a complaint or application from the State Pollution Control Board. However, the State Pollution Control Board, as in the case of the Water Act, does possess the power to direct closure, prohibition or regulation of any industry, operation or process, or to stop or regulate supply of electricity, water or any other service.